I'm Professor Dirkley, I'm Professor of Intellectual Property Law at the University of Nottingham, and I just want to take the question of the day again, which what constitutes evidence for copyright policy?
I'm not a copyright lawyer, I'm not an economist, I'm not an empirical researcher, and you may well ask why on earth am I here. Yeah, that's okay, so we can just go on to you. Okay. I'm an IT lawyer, and I'm the deputy director of a copyright centre. Life is bizarre sometimes.
First of all, I'm going to say it's a tremendous honor to be invited here, and I really do mean that. I come from a land where empirical evidence doesn't play much of a role in copyright policy at all.
This is about lawyers' response to evidence, whereas everyone else, it was their views of evidence. And the implication seems to be that lawyers don't supply evidence. Because I think lawyers do supply evidence, but maybe I'm wrong.
What I'd like to do is take my role as a lawyer very seriously. It's been a while since I wrote a brief, but nonetheless I wanted to explore how the litigation model might help us think about some of these evidentiary issues.
There's an inevitable link, and that's the lawyer talking, of course, between policy and evidence. And if policy is about economic growth, then the evidence will be to try and find proof that copyright or intellectual property rights in general foster economic growth. But I think there is much more than economic growth, and therefore there's much more than economic evidence to copyright.
So, I mean, my evidence in relation to the Digital Economy Act, which seemed to have quite a wide public uptake, even though I never sent it to the IPO, did not relate to econometrics. It related to things like rights of privacy, freedom of expression, digital inclusion, social exclusion, the impact on public Wi-Fi, wired cities, and possibly general respect for the law, because as we know, it does the law no good when you pass on enforceable laws that most people under about 30 know how to evade. So these are all not about money, but I think they do impact in the balance on the discussion of copyright policy.
Relatedly, as a political and rhetorical matter, I think those seeking a reduction in copyright protection, a lowering of the current standards, should also bear the burden of proof. I don't make this argument as a fairness argument. I advocate equal treatment for expansionists and contractionists, but not on fairness grounds. I think at least in the US, after decades of expansion of copyright law in favor of owners who submitted little evidence to justify the expansion, it really doesn't seem fair to require empirical evidence to dismantle the edifice. Nonetheless, I think this is an inevitable price that has to be paid for the acceptance of this innovation in evidence-based rulemaking.
So it's about the nature of the evidence, so the type of evidence. And the focus, as I was saying, at the UK IPO and elsewhere in general, in the decision-making bodies around the world, seems to be always about economics and economic evidence. Now, I'm not saying we shouldn't have economic evidence, but we should have more than evidence that comes from economists or for that matter, quantitative evidence. And a lot of people have already said we need just not quantitative data, we need qualitative data, we need other types of evidence, empirical research, experiments, etc. And I don't think we should discard this type of evidence. So that may be something that the UK IPO can think about.
In that there is a room for both, I think. I mean, I've been looking recently at the French Hadopi report, right? This is the report that's come out after 2 years of the success of the Hadopi system. And it's been widely reported in my kind of places as showing that Hadopi is a failure, because after 2 years and 10 million emails and so forth and so on, they've only managed to find one person, yeah? This is obviously a partial response, so I went looking for other responses, and I found quite an interesting piece that said, but hang on, the point of 3 strikes graduated response is supposed to be to educate. If you actually look at the percentage of people who receive 1 warning, about 90% of them didn't get a second warning. And if you look at the people who got a second warning, about 88% of them didn't get a 3rd warning, right? Then it stops. At this point, what I desperately wanted to know was why. I wanted the qualitative follow-up. I wanted the focus group interviews. I wanted someone to tell me, did they stop because they were terrified? Did they never listen to music again? Did they get a subscription to Spotify? Did they get a VPN? Did they get proxy? Did they join a dark net? You know, what happened next?
I quote the Prime Minister here in 2010. In November, actually, just 2 years ago, he made a speech about growth and GDP, and that growth and GDP are not the sole focus, or not the only thing we should focus about, but we should also focus about happiness and well-being of the population, and that are actually equally important as economic growth. Growth is not always good. After a certain point, if you reach a certain point of wealth, it doesn't make you happier. So if you are thinking about the utilitarian rationale for copyright law, then you have to think about at which point do we have too much IP, and at which point IP does not make us happy anymore, if that's something you think about.
Our question today, right, discreetly, is what constitutes evidence for copyright policy? Here, you know, a lawyerly litigation model, I think, is really pernicious. Quite frankly, in legal practice, anything that is relevant and persuasive is potentially admissible evidence. Here's a lawyer's view that I don't think we should adopt. And I think the model of adversarial litigation in the courtroom is a poor one when it comes to legislation and policy making, which I really think should be about finding the best evidence upon which to base policy. And in the courtroom, the question is admissible or not. If it's admissible, it goes to the jury. Here we need a filter. I think everything should be admissible and submittable to the relevant regulatory agency, but I can't remember who advocated a filter, some sort of policy group which chooses what the best evidence is to actually base the policy upon.
Is the past a guide to the future? And I would say yes and no. We don't want to repeat history when we got wrong, and that's what we learn from making mistakes. So if we learn that economic growth does not lead to happiness past a certain point, then we should revisit the goal of IP or change the law in that respect. But we can learn from our mistakes, as I was saying, through the new research on well-being.
I don't think it's enough in this context for creative industries to claim the protection of trade secret law or confidentiality law when we as academics and the government agencies can credibly promise not to misuse or reveal discrete data, and especially when we, and I really like the Hargreaves rules, promise to make all of our data acceptable for whoever wants to test and replicate our experiments. So for me, the question of what constitutes evidence is ineluctably tied to the question of whether we should allow policy to be made while the best evidence is deliberately secreted and hidden. I don't think there's any reason for policymakers to be hampered by a law set of evidentiary rules which frequently keep the best evidence from the decision maker when we're in a different context of deciding the wisdom of legislation. Stop that.